Good morning, it's Diane Schneers. Another question that I get asked quite often is, how does the court decide who is going to have domiciliary custody of the children, and how is the visitation schedule established? Now, I will tell you ahead of time that the courts provide a lot of opportunities for the parties to agree, to come to some agreements on custody and visitation. That typically happens in the hearing officer conference, which I address more thoroughly in a different video. But the court does prefer that the parents decide what's best for the children, because you know your children better than the court ever will. But if you leave it to the court to decide, the court does look at the best interest of the child factors in an attempt to ensure close, continuing, safe contact by both parents with their children moving forward after divorce. The best interest of the child factors can be found by reviewing Louisiana Civil Code Article 134. They are outlined in detail in that statute. And some of those factors include the love and affection of the children with each parent, the historical time that the children have spent with each parent, the age of the children may come into play, whether or not there's a history of abuse by either parent of the children, the capacity of each parent to provide spiritual guidance and continue the education and upbringing of the children, the permanence of the family as a unit, how long each family unit has lived together, where the children have historically stayed and slept, the moral fitness of each party as it relates directly to the welfare of the children. So any history of criminal abuse or any history of substance abuse or alcoholism is also going to be a major consideration for the court. The home and community history of the child. Where have the children typically attended school? Where have the children typically lived and slept? Where are their friends located? Where do they go to church? The distance between both parents' homes, where have the parents decided to reside after separation? The primary historical caregiving responsibilities of each parent for the children, that's a big one as well. Who's been taking them to the doctor? Who cooks the meals? Who does the shopping? Who does the laundry? Who does the shopping for food? Who does the shopping for clothes? Who sets the doctor's appointments? Who attends the PTF meetings? Has that been historically done by one parent more than another, or is that a shared responsibility in the home? And also the court will look very closely at whether or not there's been a history of physical violence between the parties, because that of course has an effect on the children, both in the past and moving forward as well. So those are the factors that the court will look at in determining custody and visitation and who is to be named domiciliary custody. Again, the court does prefer the parties to come up with their own schedule that works for them, keeping in mind that the children need close, continuing, safe contact with both parents. They, of course, love both parents. They don't need to feel like there's anything wrong with the other parent, because they are cognizant of the fact that they are half of both parents. So they're going to want to continue a loving relationship with both of their parents. And that is the goal of the court and the goal of myself as well. And visitation is flexible, but the court does like to see a more frequent exchange of custodial, physical custody visitation between the children and the parents when a child is a lot younger. They need more frequent contact. And I will talk about that and the reasons for that as well in an additional video. I hope that provides you some general information about what you should consider when you're determining who's going to act as domiciliary parent after divorce, and what kind of schedule that you want to set up for your children moving forward. Again, I am available for consult. I'm available to ask any questions that you want. I care deeply about my clients and their children. I am the voice of the children that don't have someone to speak for them through the legal process. So if you'd like to call my office for a consult, our number is 337-534-4326. Thank you.